Dig, 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 dig. I'll be a digging. You can call me Diggy. Dig, 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 dig. I was digging around the internet. I come across this AI opinion. No, I did not present it. I don't know who did actually, but it is through Perplexity.ai. And yes, I don't know where this computer person, basically AI, pulls all their data from. But this is what AI concludes on whether or not the Commonwealth proved the guilt of Karen Read, and what would AI choose if AI was a juror. This is interesting, at least to share. And yeah, I will respond for AI in a computer voice. In your opinion, do you believe, based on the evidence and conflicting testimony, that the Commonwealth of Massachusetts has proven the guilt of Karen Read in the murder of her police officer boyfriend? Answer from AI. Based on the available information, it appears there are significant conflicting accounts and evidence in the Karen Read murder trial, making it difficult to definitively conclude whether her guilt has been proven beyond a reasonable doubt. The prosecution alleges Read struck her boyfriend, John O'Keefe, with her SUV and left him to die. They cite physical evidence like broken taillight pieces at the scene and a hair on Read's bumper, as well as witness testimony about Read's statements. However, the defense argues Read was framed and that O'Keefe may have been killed inside the house where the party occurred. They point to issues with the investigation, including an unsecured crime scene, lack of home search, and questionable actions by investigators with personal ties to witnesses. There are also conflicting accounts from key witnesses. For example, Jennifer McCabe's testimony about Read's statements changed between the grand jury and trial. The defense also raised questions about a suspicious internet search by McCabe that was later deleted. Given the contradictory evidence and testimony, as well as concerns raised about the investigation's integrity, it seems there is reasonable doubt remaining. The jury's initial inability to reach a unanimous verdict further suggests the case is not clear-cut. Without access to all trial evidence, it is difficult to definitively assess whether guilt has been proven beyond a reasonable doubt. Dig. I'll be your digging. You can call me Diggy. Okay, so now let's go to the next question. They're literally going to ask AI, if you had to decide the case yourself, making AI a person who was a juror, would you say guilty or not guilty on all charges? And here is what AI said. Based on the information available and the principle of innocent until proven guilty beyond a reasonable doubt, if I had to make a decision right now, I would say not guilty on all charges. This decision is based on several factors. 1. Reasonable doubt. There appeared to be significant inconsistencies in the evidence and testimony which create reasonable doubt about Karen Read's guilt. 2. Investigative concerns. Questions raised about the integrity of the investigation, including the unsecured crime scene and potential conflicts of interest, further contribute to doubt. Alternative theories. The defense argument that Read may have been framed and that the death could have occurred inside the house presents a plausible alternative scenario that hasn't been definitively ruled out. 4. Changing witness testimony. The fact that key witness accounts have changed over time raises questions about the reliability. 5. Jury indecision. The initial inability of the jury to reach a unanimous verdict suggests that the case is not clear-cut, even to those who have seen all the evidence. 6. Presumption of innocence. In the American justice system, the burden of proof lies with the prosecution. If there's significant doubt, the default should be not guilty. It is important to note that not guilty does not necessarily mean innocent. It means the prosecution hasn't met the high bar of proving guilt beyond a reasonable doubt. Based on the conflicting information and apparent issues with the case, it seems that bar may not have been met. I am curious. So the thing about AI is AI doesn't have emotions, even if in silly movies where they act like they have emotions and, but whatever. It's just without any, anyways. But I don't know where they get all their data. Like, I'm sure there's a lot of things they probably missed, like, FBI investigations or whatever, but it's just pretty, it's a general thing. This is AI. Anyways, so I'm curious if to sometime in the future, are courts going to use as reference AI answers? I'm just curious if we're ever going to see that in a court. That absent, like, prejudicial stuff. Like, for example, you know that Alberts were sitting in McCabe in that jury pool, and a lot of people think that the Keefs had them there, but I'm not sure that's the case. I think they just chose to sit there, you know, because they wanted, the DA wanted them to see they're there, sitting next to the family. The family's like friends with them, like they wouldn't do this to these people. They wouldn't do that. I mean, they're friends. See, they wouldn't do this. You know, I don't know. It's kind of a speculation, but AI. What do you think? Oh my gosh, AI is giving opinions on cases. But what's so wild is AI is absolutely what everybody is saying. It's still 80-20, and I think it's higher. The consensus across the internet, and I'm not just talking about biased streams where everybody there is, you know, doing polls and it's pretty much biased, you know, the people they're for one or another. I'm talking pretty much consistently comments across the internet is absolutely 80-20. 80-20. It's pretty a steady average. It may be higher in some places, meaning, you know, higher, 80% for they're guilty, the state is guilty, and she's innocent. 20 is for, well, I'm not sure, or, you know, they're just not accepting that the police could do this, or they just didn't watch the trial, or for whatever reason, they've just dug their heels in and say they just want to hate on somebody and hate on her. So it's probably been the highest all for one person that I've seen, other than people hating on a defendant, and, you know, so much so that, I mean, I don't think this is kind of, it's very rare to have that many people for a defendant that's not a celebrity. You know what I mean? She's not a celebrity. She kind of is now. I hope she uses her platform of having become infamous to, and she kind of already has, on the steps this 12-year-old child traveled because what Proctor said about people with colostomy bags, and he's a child with a colostomy bag, and he was very upset, and so he came out to have a sign showing out his outrage against, you know, the state of Massachusetts for employing him and how discriminating that was to people with disabilities. And he should be talking about our medical stuff anyways. Nobody's talking about the HIPAA violations. Anywho, so this is AI Answer, guys. What do you think? Oh my gosh, I've never looked at an AI opinion of a legal case before, so this is interesting. I'm a before internet era person, so this is the world we're coming into now. But they're correct, though. I mean, they're just, yeah. So AI says Karen Read is not guilty. Now, it does note that it doesn't mean necessarily she's innocent, just that based on, at the very least, reasonable doubt. And that's what the question was. You know, if you had to decide the case yourself right now, meaning AI, would you say guilty or not guilty? And their answer addresses the reasonable doubt. Not guilty. And without saying, you know, any other thing that could possibly have happened. Just based on what they presented, the reasonable doubt. It doesn't mean innocent, but it means that for what they have presented has not been met. Nor proven. So, there you go, guys. AI has spoken. Dig, 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 dig. I'll be your digging. Have a blessed weekend. Bye.